Welcome to Talk Trials. I am ready to get into the weeds if you are.
Hi, I've got my shovel. Let's dig.
We are looking at a case today that, on its face, seems like the standard political football we say every June.
Right.
It's got all the key words that usually light up the cable news chyrons. Planned Parenthood, Medicaid, abortion, red state versus blue policy. It feels like a culture war skirmish.
Absolutely. And you'd be forgiven for thinking that's all it is.
But if you stop there, if you just read the headlines, you miss the actual earthquake happening underneath.
That is exactly right. If you focus on the politics, you miss the procedure. And in this case, the procedure is the whole ballgame.
I see.
This case isn't really about abortion access, at least not in the direct legal sense. It's about the machinery of the American lawsuit. It asks a fundamental question. When the federal government makes a promise in a spending bill, when they hand out cash with strings attached, who actually gets to enforce those strings?
The case is Medina, Director, South Carolina Department of Health and Human Services v. Planned Parenthood South Atlantic et al. It was decided on June 26, 2025. And frankly, the stakes here are massive.
They really are.
We're talking about the ability of private citizens to sue state officials when they believe a federal spending statute is being violated.
Specifically, we're wrestling with the any qualified provider provision of the Medicaid Act. And the million-dollar question, or really the multi-billion-dollar question, is whether that provision confers an individual right that is enforceable under 42 U.S.C. Section 1983.
Okay, let's unpack this right out of the gate, because 42 U.S.C. Section 1983 is a mouthful of legalese, but it's also one of the most important numbers in American life.
It's huge.
This is a statute that lets people sue state officials for violating their civil rights right.
That is the one. Think of Section 1983 as a vehicle. It doesn't create any rights on its own. It's just a car.
A car, okay.
You get in the car to drive to federal court when someone else, usually the Constitution or federal law, has built a road by giving you a right.
Ah, I like that analogy.
But if the underlying law didn't build a road, if it didn't create a right, then the Section 1983 car can't go anywhere. You're just sitting in the driveway.
And in this case, the parties are fighting over whether the Medicaid Act built that road.
Exactly.
We have the petitioner, Medina, representing South Carolina's Department of Health and Human Services. And on the other side, the respondents are Planned Parenthood South Atlantic and, critically, an individual patient named Julie Edwards.
And the presence of the patient is key. It is so important.
Why is that?
Because the question is, does the Medicaid Act just give money to the states with some instructions attached for the bureaucrats? Or does it actually give you, the patient, a concrete enforceable right that you can vindicate in court?
Let's get a snapshot of what went down before we really dive into the deep end of the legal theory. What was the conflict that started all of this?
It started back in 2018. The governor of South Carolina issued an executive order. The state decided to terminate Planned Parenthood's enrollment in the South Carolina Medicaid program. They essentially said, you are no longer a qualified provider in our state system.
And the reason wasn't about the quality of care, right? They weren't failing health inspections or anything like that.
No, nothing like that. The explicit reason was that Planned Parenthood provides abortions.
Right.
Now, it is important to note for context that Planned Parenthood offers a wide range of services: gynecological care, family planning, cancer screenings, diabetes management, all sorts of things.
And crucially, federal Medicaid dollars were already not paying for the abortions due to the Hyde Amendment.
That's the part that often gets lost. This wasn't about public funds for abortion, but South Carolina's policy was to exclude them entirely from the program based on the fact that they performed abortions separately.
So Julie Edwards, a patient who relied on Planned Parenthood for things like birth control and managing her diabetes, gets caught in the middle.
Completely.
She sues under Section 1983.
Exactly. Her argument was that the Medicaid Act has a specific provision, Section 1396A, which says a state plan must ensure that any eligible individual can obtain assistance from any qualified provider who is willing to provide the service.
Any qualified provider.
Right. She argued this guarantees her a free choice of provider. She said, the feds gave me a choice and the state is taking it away.
And South Carolina's response basically was, tough luck, you don't have a right to sue us over this.
That's the procedural core of it, yes.
And the Supreme Court agreed.
They did. In a 6-3 decision, the Supreme Court reversed the Fourth Circuit. South Carolina won.
Lay out the ruling for us.
Justice Gorsuch delivered the opinion, joined by Chief Justice Roberts and Justices Thomas, Alito, Kavanaugh, and Barrett.
So the whole conservative wing.
The whole conservative wing, yes. The court ruled that Section 1396A, 23, does not clear the high bar required to create an individual right enforceable under Section 1983. They said the language was not unambiguous enough.
We'll be talking a lot about that word, unambiguous.
Oh, yes, it's the linchpin.
We also had a concurrence and a dissent, right?
Yes. Justice Thomas filed a concurrence arguing that the court should go even further and restrict these lawsuits almost entirely.
Which is pretty typical for him on this issue.
It is. And Justice Jackson filed dissent, joined by Justices Sotomayor and Kagan, arguing that the court is stripping away rights that Congress clearly intended to give.
It feels like a significant tonal shift in how we handle these safety net programs.
It is a reinforcement of a shift that has been happening for 20 years. This decision cements a very high barrier. The message is, if you want to privately enforce a condition of federal funding, you need Congress to have been incredibly explicitly clear that they were giving you that power.
So no more reading between the lines.
The days of assuming a law creates a right are effectively over.
All right, let's take a breath and really dive into this. We need to understand the machinery here. Part one, the background. We need to talk about the Medicaid bargain.
Yes.
I feel like people think Medicaid is just a program the feds run, like the post office.
Far from it. This is where constitutional structure matters. The federal government actually has very little power to force states to do things directly.
The 10th Amendment.
The 10th Amendment and the anti-commandeering doctrine, exactly. Washington can't just order the South Carolina legislature to pass a specific health care law. That's a no-go.
So they use the power of the purse, the golden rule. He who has the gold makes the rules.
Exactly. It operates under the spending clause of the Constitution. The feds say, we have this massive pile of cash. If you want it, you have to sign this contract.
And that contract is the Medicaid Act.
It is. It's voluntary, technically. But if the state takes the money, they agree to a plan. That plan has to satisfy over 80 different conditions listed in the statute.
80, wow.
Over 80. It's a hugely complex piece of legislation.
And one of those 80 conditions is this any qualified provider rule.
Right. It is item number 23 on the list. The text says a state plan must provide that any individual eligible for medical assistance may obtain such assistance from any provider qualified to perform the service.
Any individual may obtain. Hold on to that phrase because we are going to fight over those four words for the next hour.
We certainly are.
To a layperson, that sounds a lot like right, I may obtain this.
It certainly sounds like it creates an entitlement, and that is what Julie Edwards and Planned Parenthood argued.
And initially, they were successful.
They were. They won at the district court. They won at the Fourth Circuit Court of Appeals. The lower courts looked at that text and said, yes, this creates a right for the patient to choose their doctor, and South Carolina cannot take that away just because they dislike the provider's other activities.
But this case took a weird detour before getting to the Supreme Court this time, right? Something about a nursing home case.
Yes, the Tlefsky interlude. This is really important procedural background.
So what happened?
The Supreme Court had actually sent this Medina case back down to the Fourth Circuit previously. They said, reconsider this in light of our decision in Health and Hospital Corporation of Marion County v. Tlefsky.
Okay, remind us what Tlefsky was. That was a big one recently.
Tlefsky was a case decided regarding the Federal Nursing Home Reform Act, or FNHRA. In that case, the Supreme Court actually found an enforceable right.
They found one, so the patient won.
Patient won. They said a nursing home patient could sue under Section 1983 to enforce a right against unnecessary chemical restraints.
So the Fourth Circuit looks at Tlefsky, where the patient won, and looked back at the Medicaid provider case and said, okay, we're still right.
Exactly. They reaffirmed their decision. They looked at Tlefsky and said, see, this supports our reasoning. They thought Tlefsky supported them because both laws dealt with healthcare funding and protecting patients.
But that's not how the Supreme Court saw it.
Not at all. The Supreme Court took the case up again to resolve a split among the circuit courts. And this time, they said the Fourth Circuit got it wrong.
Which brings us to the main event, Part 2. The majority opinion by Justice Gorsuch. How does he get around the fact that Tlefsky found a right in a similar context? What's the distinction he's drawing?
Justice Gorsuch starts by setting the table with first principles regarding Section 1983. He's very methodical.
Laying the groundwork.
He emphasizes that Section 1983 is a vehicle to enforce rights, not just benefits or vague interests. And he leans heavily on the separation of powers.
Meaning it's Congress's job to decide who gets to sue, not the courts.
Correct. He argues that courts should not imply private rights of action lightly. If Congress wants to allow patients to sue states, Congress needs to say so clearly.
No judicial activism, in his view.
Precisely. He uses that contract analogy we discussed. If the spending clause is a contract between the feds and the state, you have to be very careful about letting a third party the patient sue to enforce that contract. The state must knowingly accept that liability.
So the state has to know, if I take this money, Julie Edwards can sue me. It has to be that clear.
Yes. Congress must speak with a clear voice. This leads us to the test derived from Gonzaga University v. Doe and reaffirmed in Tlefsky. It is a demanding bar.
What's the test?
The statute must unambiguously confer individual rights.
Unambiguously. That's a tough word in law. It means no other interpretation is possible.
It is. It's an incredibly high standard. Gorsuch argues that finding an enforceable right in a spending statute is the atypical case. It is the exception, not the norm.
So the default position is no right to sue.
That's the default. To overcome it, the statute must use rights-creating language.
And this is where the comparison to Tlefsky gets really technical. Gorsuch says the Medicaid provision just doesn't sound like the Nursing Home Act.
That is the crux of the majority's textual argument. It's a deep dive into the specific words Congress chose.
Let's get into it.
In Tlefsky, the statute regarding nursing homes explicitly used the word rights. It had a section titled Requirements Relating to Residents' Rights.
Okay, that's pretty clear.
It's very clear. It listed the right to be free from restraints and the right to choose a personal attending physician.
It literally said the right to.
Yeah.
It beat the reader over the head with it.
It did. Gorsuch compares that to Section 1396AAA. The Medicaid provision doesn't use the word right.
No, it says the state plan must provide that an individual may obtain assistance.
And Gorsuch views this as a directive to the Secretary of Health and Human Services about what the plan must look like. It's an instruction to the government, not a declaration of rights for the patient.
It's a subtle distinction, but I see it. One says you have a right, the other says the plan must allow you to. It's a focus on the state's obligations versus the individual's entitlement.
And Gorsuch piles on more evidence for this view. He points to the felony exception.
What's that?
The any qualified provider provision allows states to exclude providers who have been convicted of a felony related to, healthcare fraud or patient abuse.
That seems reasonable. You don't want criminals running clinics.
Of course.
Yeah.
It is reasonable policy, but Gorsuch argues it creates a logical inconsistency if you view this as an absolute individual right.
Oh.
He says, if this were a right granted to the patient, why does the state get to determine which felonies disqualify a provider? Why does the state have so much say? He argues that Congress would be granting a right in one breath while letting states control its scope in the next.
So because the state has some control over who is qualified, it can't be an unlimited right for the patient.
Precisely. It suggests the provision is about the system, not the individual. It's about giving states flexibility to manage their provider networks, not giving patients an ironclad right.
Interesting. What other arguments does he make?
He also looks at the concept of aggregate compliance. The Medicaid Act requires the state to substantially comply with the rules to get funding.
Substantially comply, not perfectly comply.
Exactly. It doesn't require 100% perfection in every single instance. Mm-hmm. Gorsuch argues this focus on substantial aggregate compliance shows the law is about the relationship between the state and the federal government. It's about the overall health of the program.
Not the vindication of rights for specific persons.
That's the key phrase. If the law says the state generally needs to have a system that works, that implies the enforcement mechanism is a conversation between the feds and the state about the overall system.
Whereas if the law says Julie has a right to X, that implies Julie can sue if she doesn't get X.
Exactly. Gorsuch says Medicaid looks more like the system-wide rule. The remedy for noncompliance is for the Secretary of HHS to talk to the state, maybe withhold some funds, but not for an individual to bring a lawsuit.
And then there's the placement argument. Where is this text found?
This is a structural point he really emphasizes.
It's buried, right?
It is item 23 in a list of 87 requirements for state plans.
87.
Gorsuch argues that this provision is just one of many checkboxes the Secretary of HHS has to review. It isn't set apart as a Bill of Rights for patients, unlike the Nursing Home Reform Act in Tlefsky, which had its own distinct section for rights.
So the structure of the statute itself tells a story.
In his view, it tells you this is just another administrative detail for the state plan, not a profound statement of individual liberty.
So no magic words, no right section, too much state control, therefore no lawsuit.
That is the majority's conclusion in a nutshell.
But the plaintiffs didn't just roll over. They had counter-arguments. Let's look at part 3, the rebuttals. Because, frankly, any individual may obtain sounds a hell of a lot like a right to me.
And to the Fourth Circuit and to 3 justices of the Supreme Court.
They brought up Medicare, didn't they? How did that comparison play out?
They did. This was a really interesting textual point. They pointed out that Medicare has a provision titled Free Choice by Patient Guaranteed.
Guaranteed. That sounds strong. That sounds like a right.
It does. But Gorsuch, in a classic textualist move, turns this around on them. He points out that the Medicaid provision omits the word guaranteed. He says this implies a deliberate choice by Congress to not grant the same level of right in Medicaid that exists in Medicare.
So the argument is Congress knew how to write a guarantee, they did it in Medicare, and they chose not to do it here.
Exactly. If they wanted to guarantee it, they knew how to use the word. They didn't. That silence speaks volumes to the majority.
That is the negative implication canon of statutory interpretation. What's not there is just as important as what is there.
A powerful tool for a textualist.
Ouch. And then there's legislative history. The plaintiffs argued heavily that Congress intended to stop states from steering patients to specific doctors. There are committee reports and statements from the time saying exactly that.
Yes, the dissent leans on this heavily. The historical context seems clear.
But Gorsuch isn't a fan of digging through congressional archives.
No. He is famously skeptical of legislative history. He dismisses this argument pretty quickly. He says legislative history is not law.
Right.
In spending clause cases, what matters is what the states were clearly told in the text of the contract. You can't hold a state liable based on what Congress secretly intended in a committee report that the state legislature probably never read.
So the notice of the state has to be in the final enacted statutory text. Period.
Period. It has to be on the page.
And then there is the magic words critique. The dissent and the plaintiffs say, come on, your demand, we say Simon says right, or it doesn't count. They're accusing the majority of being overly formalistic.
Gorsuch defends against this. He says the court isn't demanding magic words, but it is demanding the level of clarity found in Tlefsky.
So Tlefsky becomes the new floor.
It becomes the benchmark. He argues that if the court adopted the dissent's view, that individual-centric language is enough, it would turn the exception into the rule.
What does he mean by that?
Suddenly, every one of those 87 requirements in the Medicaid plan that mentions an individual would become a ground for a federal lawsuit. He paints a picture of the federal courts being flooded with litigation over every minor detail of state Medicaid administration.
A floodgates argument.
A classic floodgates argument. He's saying the dissent's approach would radically alter the federal-state balance.
That brings up the policy argument. The plaintiffs say, if we can't sue, this law has no teeth. Because let's be honest, is the federal government really going to cut off all Medicaid funding to South Carolina just because they kicked out one provider?
That is the nuclear option argument. The plaintiffs say funding termination is too drastic, so it never happens. It's a bluff. Therefore, private lawsuits are necessary to enforce the law.
If the only punishment is the death penalty for the whole program, the state knows the feds will never pull the trigger, so they can break the rules with impunity.
It's a very powerful, practical argument. But Gorsuch rejects this.
On what grounds?
He says the nuclear option is a real remedy, even if rare, and the threat of it is often enough. But more importantly, he says balancing the costs of litigation versus enforcement is a policy choice for Congress, not the courts.
Back to separation of powers.
It all comes back to that. If Congress thinks the enforcement is too weak, Congress can amend the statute. They can explicitly create a private right of action. They can create a less drastic administrative remedy. But it is not up to the judges to invent a lawsuit just because they think the administrative remedy is insufficient.
That is a very restrained view of judicial power.
It is. It places the burden entirely on the legislative branch, to be clear.
Now let's pivot to part 4. Justice Thomas filed a concurrence. He voted with a majority, but he had some things to get off his chest.
Justice Thomas is playing a longer game here. He agrees with the outcome, but he thinks the court's entire approach to Section 1983 and the spending clause is flawed. He's been saying this for years.
He wants to tear it down and rebuild it.
Essentially. He wants to go back to the original meaning. He revisits the history of Section 1983. Remember, this was passed in 1871. It was the Ku Klux Klan Act.
Right, a Reconstruction-era statute.
It was designed to protect newly freed slaves and unionists from state-sponsored violence and deprivation of civil rights security of person and property, core fundamental rights.
Right, not necessarily to guarantee you could choose which clinic treats your diabetes.
Exactly. Thomas argues that Section 1983 was never meant for modern entitlement programs. He questions whether the framers of that law in 1871 would have understood a right to a specific Medicaid provider as the kind of thing they were protecting.
So he wants to narrow the scope of Section 1983 itself.
Drastically. He reiterates his dissent from Talevsky, applying strict contract law analysis. He says that in a contract between the state and the Fed, a third party, the patient generally shouldn't be able to sue to enforce that contract unless they are explicitly authorized as a beneficiary with enforcement power.
Like in a normal contract dispute.
Precisely. He's questioning the very definition of a right in this context. He asks whether modern entitlements, benefits granted by the government, are really rights in the 1871 sense of the word.
That's a deep historical argument.
It is. He suggests the court should stop looking at whether the language is unambiguous and start asking if these are even the kinds of rights Section 1983 protects at all.
That would be a massive change if the whole court adopted it. It would effectively bar almost all private lawsuits to enforce spending conditions.
It would be a revolution in this area of law, but for now, it's a concurrence.
Let's look at the other side, Part 5, the dissent. Justice Jackson, joined by Sotomayor and Kagan, she came out swinging.
She certainly did. Justice Jackson opens with that grand ambition of the Civil Rights Act of 1871.
A completely different historical frame than Thomas.
A completely different view. She argues the statute was meant to be broad to protect citizens against state deprivations of all rights secured by federal law, not just the ones that existed in 1871.
She looks at the text, any individual may obtain, and sees something very different from Gorsuch.
She sees a clear right. She argues that this is rights-creating language. It is mandatory. It says the plan must provide, and it is individual-centric. It focuses on any individual. To her, that meets the Gonzaga test.
So she thinks the majority is adding new requirements to the test.
She essentially accuses the majority of moving the goalposts. She says the court is inventing new hurdles that aren't in the precedent.
She points out the original title of the provision too, right?
Yes. This is a key part of her textual argument. The original session law heading was free choice by individuals.
Free choice.
She argues this clearly signals an intent to create a right. Free choice sounds a lot like a right, much more so than just a plan requirement.
What about the comparison to the Nursing Home Act? Gorsuch said this law doesn't look like that one.
Jackson critiques that as formalism. She says it's a sterile, mechanical comparison.
What does she mean by that?
She argues the majority is effectively requiring Congress to copy-paste the exact language from the Nursing Home Reform Act to create a right in any other context.
So unless it's a carbon copy of the Talevsky statute, it doesn't count.
That's her critique. She says laws means laws. Section 1983 applies to all laws, not just those that look exactly like the one in Talevsky. She's warning against creating a super statute that all other statutes have to mimic.
And she hits hard on the real-world impact. This seems to be a hallmark of her jurisprudence.
This is a key part of her judicial philosophy. She's very focused on how these decisions affect people's lives. She emphasizes that the administrative remedy HHS cutting funds is hollow.
Hollow.
It's unrealistic. It hurts the very beneficiaries the act is meant to help. If you cut funding to South Carolina's Medicaid program, the patients suffer. The state officials who made the decision don't. It's a remedy that punishes the victims.
So by stripping away the right to sue, the court is effectively allowing states to violate the law without consequence.
That is her conclusion. She argues this decision leaves Medicaid recipients in South Carolina without a way to enforce a choice Congress explicitly gave them. It allows states to steer patients, which was exactly what the provision was designed to prevent.
It is a classic clash between formalism, what does the strict text and structure allow, and functionalism, what was the law designed to do, and how do we make it work?
That is a very good way to put it. Gorsuch is focused on the form of the words. Jackson is focused on the function of the law.
So let's look at the legal context and significance. What does this ruling mean for the future? Where do we go from here?
First, it solidifies the atypical standard. The Gonzaga-Talevsky framework is now a fortress. The bar for finding an implied right of action in spending clause statutes is exceptionally high.
So if I'm a legislative drafter in Congress now,
if you are a legislative drafter and you want people to be able to sue to enforce a condition, You better use the word right. You better put it in its own section titled Rights of Beneficiaries, and you should probably add a sentence that says, this right is enforceable under Section 1983.
You have to spell it out in neon letters.
You basically have to.
What about the suitor fix? I saw that mentioned in the opinions. That was an attempt by Congress to fix this, wasn't it?
It was. That was a 1994 law where Congress tried to say, hey, just because a provision is an estate plan requirement doesn't mean it's unenforceable. They were responding to a previous Supreme Court decision.
The court here didn't give that much weight.
The majority interprets this narrowly. They say, sure, being in a plan requirement doesn't automatically disqualify it, but it doesn't guarantee enforceability either. You still need that unambiguous rights-creating language in the provision itself. The suitor fix doesn't get you there on its own.
And the separation of powers implications. This feels bigger than just Medicaid.
It is. It is the court telling plaintiffs, don't come to us to police the bargains between states and the federal executive. They are pushing these disputes out of the judiciary and into the political branches. They are leaving enforcement to HHS and Congress.
And for Medicaid litigation specifically.
It likely forecloses many future Section 1983 suits regarding other Medicaid plan requirements. If this provision, which was arguably one of the stronger ones regarding individual choice, didn't make the cut, it is hard to see how others in that list of 87 conditions will.
So what happens now?
The battleground shifts to state administrative courts, which have their own sets of rules and are often less favorable to plaintiffs. Or it becomes a political battle. You lobby HHS to be more aggressive in its enforcement.
Which is a much harder hill to climb for a regular patient.
Undoubtedly. A lawsuit is a tool for an individual. Lobbying is a tool for an organization.
All right, it is time for our favorite segment. We are stepping out of the analysis booth and putting on the robes.
The 10th chair.
We are sitting as the hypothetical 10th vote on the Supreme Court. We have heard the arguments. We have read the briefs. We've seen the draft opinions. Where do we land?
Sitting as the 10th chair, looking at Medina v. Planned Parenthood South Atlantic, I have to say this is a close one. The arguments on both sides have real force.
But the chair has to vote.
The chair has to vote. And so I am casting my vote to affirm the Fourth Circuit. I am dissenting from the actual majority.
Wow. Okay, breaking with Gorsuch. Walk us through the ratio decidendi. Why?
First, stare decisis and Tlefsky. I believe the majority misapplies Tlefsky. It reads it not as a standard, but as a one-off exception.
So you think they're narrowing it to the point of being useless?
I do. In that case, the court held that individual-centric language combined with a mandatory directive creates a right. The phrase any individual may obtain in the Medicaid Act is functionally indistinguishable from the right to be free from restraints in Tlefsky. Both confer a specific benefit on a specific class.
So you think may obtain is strong enough?
I do. It is a guarantee of access. Textually, may obtain empowers the individual. It is not just an instruction to the state, it is a promise to the patient. To say that a plan must provide that an individual may obtain something is, in my view, the functional equivalent of granting a right to it.
What about the majority's argument that it's just a plan requirement buried in a list?
I reject that formalism. The majority's reliance on the absence of the specific word right, or the placement in a content section, is overly rigid. The function of the text is to guarantee a specific liberty, the choice of provider to the beneficiary. The fact that it is listed among other requirements doesn't dilute its individual focus. A right doesn't become less of a right just because it's listed in a long document.
And the notice argument. Did South Carolina know they could be sued?
South Carolina accepted these funds, knowing the free choice provision was a condition. This isn't a new interpretation. It has been litigated for decades. The unambiguous notice requirement is satisfied by the plain text of the requirement itself. They knew they had to allow any qualified provider. They took the money, they should be held to the bargain. To allow them to take the funds and then ignore one of the core patient protection conditions seems to undermine the very nature of the spending clause arrangement.
So what is the impact of your hypothetical ruling? What does the world look like if your view prevails?
This holding would clarify that Tlefsky was not an anomaly, but the standard. If Congress uses mandatory individual-focused language, a right exists. It would prevent the hollowing out of Section 1983 in the context of social safety net legislation. It ensures that the promises made to the most vulnerable citizens in these statutes are actual legal rights, not just administrative suggestions that can be ignored by states at will.
It keeps the courthouse doors open for these kinds of claims.
It keeps the courthouse doors open and ensures that Section 1983 remains a vital tool for enforcing federal law, which I believe was its grand ambition.
A bold stance from the 10th chair today.
But as always, we must include our disclaimer.
Absolutely. Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Supreme Court.
Though it is fun to imagine if it did.
So, to recap the reality, the Supreme Court reversed the lower court. There is no Section 1983 right to sue under the Medicaid, any qualified provider provision.
A victory for a strict interpretation of spending clause notice and a significant limitation on private enforcement of Medicaid rules.
It leaves us with a provocative thought. If the nuclear option of cutting funding is too destructive to use, and private lawsuits are now off the table, what is the check on state power in federal spending programs? Is the bargain really a bargain if one side can ignore the terms with impunity?
That is the question the system will have to grapple with in the years to come. What is a right without a remedy?
Thanks for diving deep with us.
Until next time.
This has been Talk Trials. See you in court.